Ezra Levant here. It is finally over. The trial of Tamara Lich, of course, it's not over till it's over. The trial part is over. 47 days of hearings over the course of a full year. All of this 2.5 years from the trucker convoy. So that's done. But the judge says she'll need till November 26th just to review the case. On November 26th, she'll tell the lawyers when she expects she'll have the written ruling done. Could be into 2025, I don't know. This judge is very busy. She says she can't just take time off to write it. She's running other trials too, which goes to the extreme amount of resources the government has poured into this. Here's a quote from Lawrence Greenspon, the defense lawyer today, saying the only thing overwhelming in this case was not the legal validity of it or the seriousness of the offense, but the money the government threw at it. Here's Lawrence Greenspon, who was speaking to a scrum about 10 minutes ago.
Quoting a friend of mine who has numerously said that he believes that it's the longest standing mischief charge in the Commonwealth. Thank you, Ezra. And it's I can't disagree. I mean, to spend this kind of time and resources, as I said in court the other day, it's the only thing that's overwhelming in this case are the resources that the Crown has afforded to the prosecution of a mischief charge. It was essentially a mischief charge against Tamara Lich and Chris Barber. That's the only thing that's overwhelming. What does it say about the administration of justice? It's not a happy day when these kind of non-violent charges for people who have no criminal record and are before the courts for some 45 days, when there are far more serious cases before the courts that are being thrown out for delay. That's not a good comment for the administration of justice.
I'll play the rest of that scrum later in this video. It was absolutely outstanding. This was an abusive trial. There's no two ways about it. The phrase, the process is the punishment, comes to mind. 47 days of hearings over the course of a year. That's a punishment in itself. Tamara Lich has already done 49 days in jail for a mischief charge. I think that's unprecedented in Canadian history to have 49 days pre-trial custody before even being convicted. I think she'll be acquitted, by the way, but she still had the massive punishment of coming to Ottawa for this trial. And I think it did not serve the public. And I think it's clearly a vendetta. The weird thing about this vendetta is that although Justin Trudeau certainly was at the center of the national crackdown against COVID protesters and dissenters, he invoked the Emergencies Act illegally, for example. This prosecution is not a federal prosecution. These are provincial government prosecutors. That is, Doug Ford and his Attorney General made the decision to allocate these overwhelming resources to it. If it weren't for the crowd funds of hundreds of ordinary Canadians, there's no way that Tamara Lich would have stood a chance. I think, though, that the apogee of the lockdown mania has passed. And with every passing month, we realize that the skeptics, the dissenters, the contrarians were right. I think a lot of people realize that the vaccines that they took were not what was promised, and many people have buyer's remorse for accepting them. I think that even the judiciary is waking up to what it allowed. I point again to the federal court ruling that the Emergencies Act was unconstitutional. That ruling came out in January 2024. I don't think you would have seen that ruling in 2023 and for sure not in 2022. I think, as Lawrence Greenspon said, in Canada, we like to think of ourselves as liberal and freedom-loving, but we seem to smash dissidents, and it takes us years to realize it. Here's a clip of him saying that at the same press conference.
We've always backed away from a hardline position with the passage of time. That's what we did to the Sikhs on the Camarata Magoo. It's what we did to the Japanese Canadians. It's what we did to the Ukrainian Canadians. It's what we did to the members of the Separatist Party in Quebec in October 1970. We've always come down very hard on dissenters, demonstrators, protesters, people seeking to express themselves. And then later on, usually generations later, apologized for it. We're the masters of historical apology in Canada, and which is why I quoted Benjamin Franklin, because we as Canadians have always been willing to trade our freedoms for the promise of security. And we're still willing to do it today. It's something that it confounds me that historically, over and over and over again, as Canadians, we've been willing to give up our freedoms for the promise of security.
Not me.
What did when Pierre Trudeau, Justin's father, when he was confronted on the steps of Parliament with, what would you do next now that you've implemented the War Measures Act? The son implements the Emergency Measures Act. What would you do now? And his answer was, just watch me. And Canadians applauded. And Canadians loved that answer. Oh, just watch me. Let's get tough on these guys. Let's make it retroactive to have been a member of the FLQ. Let's suspend all of their rights and freedoms and their abilities to contact counsel, their right to be not to be arbitrarily detained, their right to be informed of the reasons for their arrest. Let's do all of that. And Canadians applauded. And then years later, of course, was the apology from the Premier of Quebec, Robert Bourassa. The apologies, we're very good at that. So you may be right that there may be somewhat of a backing away from the hard line, but that's so typically Canadian. It's unfortunate.
Rebel News has covered this trial every single day, not just myself, but my colleagues, Robert Kraychik, Sheila Gunn-Reid, David Menzies, and others. I've probably forgotten to mention 47 days of hearings, and that's just this trial. We've also covered the trial of the Coots 3 and other people who've been charged for that blockade. Of course, Arthur Pavlovsky, not only for keeping his church open during the lockdowns, but for going down to Coots and giving a sermon at their protest too. So Rebel News has really been part of this movement. We ourselves didn't engage in any blockades, but we were the journalists of record for the trucker convoy. We embedded our journalists in the convoy. Two of our reporters, Alexa Lavoie and Lincoln Jay, worked 23 days straight here in Ottawa in frosty weather, documenting it, because if we didn't, who would have told the story? Who would have written the history that would have become cemented? It would have been the state broadcaster, the CBC. I don't know if you recall how bad it was back then, but some reporters actually said, I'm scared to go meet a trucker. They might be violent against me. Like, it was insane, this self-propagandization, this self-radicalization by the regime media. It was only our citizen journalists and a few other citizen journalists that told the real story. And we were able to stop the government from cementing their narrative that these truckers were somehow violent or akin to the January 6th insurrectionists in the United States. That was clearly Justin Trudeau's playbook. We stopped him from doing that. We were there during the convoy, and we also helped crowdfund a legal defense, not just for the most prominent truckers, but for severely normal Canadians too, for hundreds, in fact, about 3,000 altogether were helped through our project through the Democracy Fund. I'm going to leave you with what I think was an outstanding scrum by Lawrence Greenspon. We'll play the whole thing, including the two clips I just referenced here. I've gotten to know him a little bit over the course of this trial, and I think he was an outstanding lawyer who truly believes in freedom of speech. I told him that if I am ever, God forbid, arrested myself, I want him to be my lawyer. And in fact, we've gotten his help with other Rebel News cases, including attacks on Alexa Lavoie and David Menzies. So one of the things that I've enjoyed is getting to know the freedom team that's been behind Tamara Lich, and hopefully will help us fight for civil liberties in the years ahead. Let me now leave you with this scrum, which I thought was very educational, by Lawrence Greenspon, Tamara Lich's lead lawyer.
Well, I suppose it's fitting that after 47 days of trial, we finished this case on Friday the 13th.
Could you maybe just for starters here, Lawrence, tell us why you think Tamara Lich and Chris Barber should not be found guilty in this case?
You want a 30 second summary of the
I know we just did a 45-page trial about it, but
that's no problem. A piece of cake. There was never any question that the people in the downtown core had their lives interfered with. This is always a matter of a contest between the right to enjoyment of property and the constitutionally entrenched fundamental freedom of expression. And when I say there's no contest, what I mean is that the win always goes to those who have the fundamental freedom, constitutionally protected, to express themselves in a peaceful, nonviolent way, which is the way that Tamara Lich always advocated the people in the core of the city should behave themselves. Those were her words in texts and postings, in telephone conversations. At every point, she emphasized that any demonstration would have to be and had to be, continue to be peaceful and nonviolent and lawful. In this case, as the judge has already indicated, we have the unprecedented two occasions where the judge ordered that Tamara Lich and Chris Barber should, amongst others, continue to have the right to express themselves, carrying out a peaceful and lawful demonstration. That kind of order does not exist in any case that the Crown provided. And you also have the unique circumstance, which again the judge alluded to today, which is that the police invited the protesters into the city, told them how to get into the city and where to park. A prosecution with those two elements, that's the fundamental basis of our defense.
A little more than 30 seconds, but not that.
A little more.
Do you have a sense of how Tamara Lich is feeling right now that this is over?
I was thinking about it, and it, to some extent, there's a relief that the evidence is finally over. The evidence of the lawyers' submissions is finally over. But I don't think there's a great deal of that relief because the decision is now pending, and it's going to be months before we get a decision on this.
When we met September 5th last year, it was supposed to be a 10-day trial. What does the fact that we're now more than a year later in the 45th day of the trial, what does it say about this case, the administration of justice, the whole thing?
It's, quoting a friend of mine who has numerously said that he believes that it's the longest standing mischief charge in the Commonwealth. Thank you, Ezra. And it's I can't disagree. I mean, to spend this kind of time and resources, as I said in court the other day, it's the only thing that's overwhelming in this case are the resources that the Crown has afforded to the prosecution of a mischief charge. It was essentially a mischief charge against Tamara Lich and Chris Barber. That's the only thing that's overwhelming. What does it say about the administration of justice? It's not a happy day when these kind of non-violent charges for people who have no criminal record and are before the courts for some 45 days, when there are far more serious cases before the courts that are being thrown out for delay. That's not a good comment for the administration of justice.
One of the criteria for a prosecution is it in the public interest? Do you believe that prosecuting this case at all, or with this much resources, was in the public interest?
I don't think that the prosecuting of this case in the way that it's done and the time that it's taken and the resources that that have been afforded to it, I don't think that is in the public interest. But that's not my call. I mean, that's obviously the call of somebody in the Crown's office who has decided that they're going to use Canadian taxpayer dollars and the resources that they feel necessary in order to prosecute this case.
Just to that, there was a lot of supporters of Tamara Lich and Chris Barber who attended this trial. There's some around us now. There's also some detractors who want accountability for the interference that I think we can all accept did take place during the convoy. Where should those people look for accountability of the harm that they feel that was caused by the convoy?
Well, they already have created that vehicle in the form of a civil action. There's a class action on behalf of all of the residents of the downtown area who suffered as a result of the demonstrations that were taking place. And they have a civil claim for money damages. That's the place for those individuals to be made whole. And it's as you know, from the very start, we were prepared to admit that there was interference with the daily lives of people in the downtown core. We don't seek to minimize it, but we sought to admit it in an effort to try and avoid the necessity of calling those witnesses. And the Crown objected to that and insisted on still calling those people that we heard from.
You've opposed many times the private property right and the constitutional free expression right. Isn't there a risk of giving precedence to this constitutional right that now anyone could ignore property right and could manifest, there could be protests on people's private property? If the judge rules in your favor, it seems to really take out any limit for protests, no?
No, I think there's the charter right for freedom of expression and freedom of assembly is always subject to Section 1 of the Charter, which talks about such reasonable limits as can be demonstrably justified in a free and democratic society. So we have in Canada, that's the very first clause in our Charter of Rights. We start with what we refer to as the Mack Truck Clause, because you could drive a Mack truck through that Section 1, and it's been done. In cases where freedom of expression, freedom of peaceful assembly have been violated or been breached, the first measure is for the government to try and justify it as a reasonable limit. Now, when you talk about the contest between property rights and freedom of assembly, freedom of expression, our Court of Appeal in Ontario, in Tremblay, basically said there is no contest. Freedom of expression, freedom of peaceful assembly wins every time. That's what I meant when I said no contest. It's not that there isn't a contest between the two. It's what I meant, what I intended it to be heard is that in that contest, freedom of expression and freedom of peaceful assembly should win every time. And when they won't win, to your question, when they won't win is when there are acts of violence which go beyond freedom of expression, beyond freedom of peaceful assembly. Those are the circumstances under which, in that contest, rare as it may be, freedom of expression will not prevail.
It's been 2.5 years, and I think some of the mania, COVID mania and phobia has receded a bit. Justice Mosley's decision shows that the establishment is sort of unclenching their fists. Do you think that the establishment got carried away, the authorities got carried away and realized that they violated civil liberties? Or do you think there are still police, prosecutors, politicians who think that the Emergencies Act and their extreme policing was normal? I sense the establishment backing away from their hardline position with the passage of time.
But that's what Canada has always done. We've always backed away from a hardline position with the passage of time. That's what we did to the Sikhs on the Camarata Magoo. It's what we did to the Japanese Canadians. It's what we did to the Ukrainian Canadians. It's what we did to the members of the Separatist Party in Quebec in October 1970. We've always come down very hard on dissenters, demonstrators, protesters, people seeking to express themselves, and then later on, usually generations later, apologized for it. We're the masters of historical apology in Canada, and which is why I quoted Benjamin Franklin, because we as Canadians have always been willing to trade our freedoms for the promise of security, and we're still willing to do it today. It's something that it confounds me that historically, over and over and over again, as Canadians, we've been willing to give up our freedoms for the promise of security.
Not me.
What did when Pierre Trudeau, Justin's father, when he was confronted on the steps of Parliament with, what would you do next now that you've implemented the War Measures Act? The son implements the Emergency Measures Act. what would you do now? And his answer was, just watch me. And Canadians applauded. And Canadians loved that answer. Oh, just watch me. Let's get tough on these guys. Let's make it retroactive to have been a member of the FLQ. Let's suspend all of their rights and freedoms and their abilities to contact counsel, their right to be not to be arbitrarily detained, their right to be informed of the reasons for their arrest. Let's do all of that. And Canadians applauded. And then years later, of course, was the apology from the Premier of Quebec, Robert Bourassa. The apologies, we're very good at that. So you may be right that there may be somewhat of a backing away from the hard line, but that's so typically Canadian. It's unfortunate.
How do you feel the verdict for this particular trial is going to have an impact on individualism and individual rights in this country going forward?
Well, in a sense, I mean, I don't think we're ever going to see a situation. The Ottawa police have certainly indicated that. There's never going to be a situation where they're going to let big rigs into the core of the city again. That's not going to happen again. Is it going to have an impact on people's freedom of expression, the right to protest? I think it will. Of course, you know, the attitude, it's really an attitude that needs changing. And the attitude is, yes, well, I'm in favor of freedom of assembly and peaceful expression, but could you do it over there? Because that way it won't bother my business and it won't affect us as much. That's, you know, even in this trial. Well, you know, we let them into the city, but, you know, there's a time limit on freedom of expression. Oh, yeah? Where? Where's that time limit? They knew these individuals were coming into town and they were going to stay until the mandates were changed. And they let them into the city, they directed them how to get in here, told them which routes to take, and told them where to park. And that's not something that you've ever seen in any of the other protests. So to your question, is it going to have an effect long term? It may well, but until we as Canadians start to stand up, really stand up for fundamental freedoms that are in our Constitution, until we say no, those are fundamental freedoms and they're not to be compromised unless the government can justify it, then we won't be able to take any steps forward, unfortunately.
Well, that's it from here in Ottawa. If you want to follow all our coverage on this story and the other trucker trials, well, then go to truckertrials.com. And by the way, if you want to chip in to help us crowdfund our expenses, I'd be grateful for it. All the money we raise for Tamara Lich or for the Coutts defendants, we give to their lawyers. We don't keep a penny back from that. In fact, if you want a full accounting, you can see the Democracy Fund's charity listing on the CRA website. So we don't take any of the dough that we use for crowdfunding. So if you can help us cover the cost of our journalism, I'd be really grateful. You can do that at the website truckertrials.com. For Rebel News in Ottawa, I'm Ezra Levant.